the amount that have been kind of calculated is well beyond what is available at the end of my payroll, at the end of my cost of living, by almost double, if not even more.
He was recently diagnosed with type 2 diabetes. When I spoke with him at the pre-hearing on September 24th, he did not claim, nor has he since provided any sort of medical documentation that indicates that he is incapable of working or is on any sort of restriction.
On her time, she overdosed on heroin. The kid, the son, I believe, was almost 16, had to call 911. She was taken to the hospital for a couple of days. If she's keeping the kids from you at times that you're allowed to have them, and you think that's inappropriate, you file a complaint with a friend of the court, they investigate it. You guys can't.
Where is all this money supposed to come from?
The PPO doesn't get to continue to punish me for everything.
I asked him to provide me with proof of income, and he was like mystified that I would ask him.
There was a child that was conceived during the marriage, but is not the plaintiff's or the defendant's child. Is that correct?
Correct.
You're both women, and so it's an impossibility to have that. My question to you is something like the defendant's egg was not implanted in you or something for that child. Is that correct? Both parties are present via Zoom. This is a motion by the plaintiff to enforce the judgment of divorce. There are certain issues that have not been timely handled. First being uniform child support or spousal support. She claims that it was to start on 6/1/24 and you're not paying the correct amount. Is that correct, sir?
I am not sure on that.
It's $500 a month. I mean, what aren't you sure about?
I haven't looked into that. I don't know how much she's getting out of my check every week. I don't get a check stub.
Well, ma'am, what do you get?
$115 a week. And the whole first month of June, I've gotten nothing.
Well, contact the friend of the court because I believe they will enforce that if they need to.
Okay, I did do that to explain because I wasn't, when I first got a couple checks, I was like, what's, because it didn't equal the alimony amount or spousal support. So I looked into that for Tom and I told him that he had to call friend of the court or he had to go to his HR at his work to change that. And so I explained that to him.
And so what do you want me to do? He's ordered to pay $500 a month, make sure it gets paid correctly, or else I guess you can file an order for contempt of court if that happens. I mean, what do you expect me to do today? Pay $500 a month starting January 1, 2024. If you get far enough behind and she files an order for contempt of court, I'll hold you in contempt and fine you. None more than that. If I think the friend of the court will enforce it, but quite frankly, it sounds like he's paying almost the correct amount. If you're getting $115 from a weekly check, that's 460 plus a little bit more, because it's weekly. So there's 4.3 weeks, and that sounds like the correct amount.
It's almost, you're right. It's almost the correct amount, but it's not the correct amount. And then I still didn't get anything for June. So there's a whole 500 that he's behind on.
Well, part of it is he probably started having it taken out. It takes a while for it to go through the system. It's just the way it is.
Okay. And then, yeah.
Number 2 is the house was to be listed for sale by 8/15/2024. Is it listed for sale yet, sir?
It is not yet, no.
Why?
I haven't had the time to go through all the realtors that she sent over to me.
Well, then if that's your excuse, because for God's sakes,
it's not an excuse. It's the truth. No excuses for what I've done.
2 months and you haven't been able to, and it was listed, it had to be listed like 3 months after the judgment. I mean, are you telling me you haven't been able to figure it out? I mean, I'm going to tell you, if it's not listed in 7 days, I'm going to let her do all the listing. I'm going to let her do everything.
What's everything?
She'll be responsible to list it. She'll be responsible to sign off on it, do everything. She'll pick the realtor. And you'll have to cooperate. I mean, come on. This is 2 months past when you're supposed to have it listed.
Okay.
And
You need to
sent
figure
him
out
a
realtor. What?
I sent him a realtor 2 months after the divorce, and
She never got a hold of me.
I said that she tried texting him and emailing him, and he said that I may have missed those.
Who's the
But I
realtor
sent
you
all
want?
her information.
Who is the realtor?
Well, I forget her name now because I haven't talked to her in a couple months because he wasn't getting back to her. And I said, well, maybe he's not ready yet. And he wasn't talking to me. He blocked me. So
The house will be listed for sale by you'll have a realtor there with it by October 28th. You can send him a list of realtors if he
did.
doesn't. What?
I got a list.
I did that.
I haven't finished going through them yet.
Well, if she comes back in 2 weeks from now, I'm gonna pick a realtor.
Sounds good.
You want me to pick one now?
No, you said 2 weeks, I thought.
I'm saying if she comes back in 2 weeks and it hasn't been listed, because
Yeah.
you can renotice this for 2 weeks. If it's not listed by then, appropriately come
Okay.
back and
Yep.
and I'll list it.
Sounds good.
Number 3, the won't provide the third party with information for a quadro. Have you provided it, sir?
For what?
For drafting of the quadro.
The 401k.
I thought that was already done.
No.
It says right in the judgment, and I can find it, that she's gonna hire the person to draft the quadro. You have to cooperate and give them information about the quadro. Like what the fund is. They can't just pick it out of clean air.
Well, who is the person?
And her name is Beth. And there's been 3 attempts to get a hold of Tom through email and his attorney that he had for the divorce. And nobody is getting back to her.
She's tried getting a hold of me?
3 times.
Oh, well, that's news to me.
And I've told you that. I've
No, you did not.
told you that Beth is a quadro lady I've been talking to for the 401k.
Okay, I'm not
She
gonna.
needs
I'm not
to
gonna
know the
argue.
plan. She
wanna
cannot move forward, and I can't even pay her till she knows the plan because she can't just pull it out of thin air.
You have
She needs to
information
know.
on who she is right now, ma'am?
I would have to get into my phone. I have emails, but it's Beth, and I do have it's an email. It's contact us at quadroexpresslk.com. Tom should have it in emails.
You're gonna have to text me that.
Okay.
She'll text it to you later today. You better get on it immediately. I mean, this is starting to sound like you're just burying your head in the sand and you're not going to convince me
I'm gonna
otherwise.
be homeless here soon. I mean,
Pardon
Not
me?
gonna be homeless.
I'm gonna be homeless here soon. So
You agreed to the judgment. That's what it is. You're gonna follow the judgment, or you'll be spending a lot more money. Trust me.
Okay, I hear you.
I'm tired of this right now. And also, you're supposed to provide a statement from the Oaks stocks. Is that what?
Yep. The OAK stocks. Yep.
You're supposed to provide that because there was apparently investments in it that you're entitled to get back. Is that correct?
Yes.
Why
It's
haven't
like
you
1,000.
provided that? It says
that what
right
they
in the
talk about?
judgment that you're supposed to.
Is that with Beth?
No, I don't know how you do that one.
Sir, it says right in the judgment.
Seen any paperwork on any of this?
You do. Our judgment, our
Where?
divorce judgment.
Well,
The
says
divorce
everything.
judgment says it in there.
I understand the judgment, but I thought I was supposed to get some paperwork on all this.
You're supposed to provide it.
I don't have the information on what, okay. Never
It
mind.
says the defendant will pay the plaintiff 50% of what he paid into OAK stocks as of May 15, 2024. Defendant shall provide a statement of the amount he has paid into the stocks. The payment for this shall be taken out of defendant's portion of the house sale. You're supposed to have provided it back in May.
Okay,
Provide it in 2 weeks or if she comes back, I'm not gonna play around anymore. If you're either gonna provide this stuff, it's in your judgment, better talk to your attorney about it. Because I'm gonna enforce the judgment. You agreed to it. You're going to follow through. Or else. We will, as I say, spousal support, I'm not gonna do anything about. He's paying it out of his check. Whatever happens, if you wanna go to the FOC for enforcement, go to the FOC. As far as
Okay.
the house will be listed for sale with an agreed upon realtor by 10/28. Or you can come back to the court.
Okay.
You will contact the person that she is going to provide to you, that I think she already has, but regarding the quadro, that'll be done. You will contact that person within 1 week from today's date, which is the 25th. And you will also provide the statement that's required regarding the stocks by 10/25 also. If he does not provide it, just renotice the motion.
Okay,
You'll have to give him appropriate notice. Good luck, everybody. Thank you. We're adjourned.
thank you.
There's a motion that's been filed by the defendant, Mr. Fort, regarding custody, judgment of divorce in 2015, week on, week off. He is seeking to modify that to give him primary custody. He says that on 10/6/24, apparently, on her time, she overdosed on heroin. The kid, the son, I believe, was almost 16, had to call 911. She was taken to the hospital for a couple of days. That's what you are saying is for your proper cause of change of circumstance for change of custody. I read her response, which says it was an isolated incident, doesn't want the kids to change schools, stuff like that. Anything else you want to briefly add, sir, regarding your motion?
No, that's all I have.
All right, ma'am, I read your response. It's an isolated incident, but it's a bad incident for the kids to be there. Is there anything else you want to say?
Yeah, absolutely. My lapse in judgment shouldn't affect the children. I know what I did was absolutely wrong. It was isolated and
it does affect the children.
oh, absolutely. I go to the VA. I'm a peer support specialist. I'm going to be seeing the person who trained me in peer support as my substance abuse counselor. I have many appointments set up I have a peer support specialist. I see her today after this, a therapist and a med provider. I'm the one that does my son's IEPs. You can see here that he does never show up. To the school. I do all the school conferences. I make the dentist appointments and the doctor.
And I got that from all of your thing here.
Yes.
Let me just explain to you this. I think what I do today does not change custody. It sets up a hearing to see whether custody should be changed. All right. Because I believe what he said is enough that would fulfill Vadvarka. Vadvarka is a case that says if there's proper cause or a change of circumstance that could affect the children. Okay, this could affect the children, that kind of stuff. All right.
Yes.
So I believe he has met the burden to have an evidentiary hearing to determine if custody should be changed. In the meantime, there's nothing that really changes. There isn't, I mean, sir, you're not intending to change the kids' schools and stuff like this, I take it. And in fact, I'm not even really allowed to change the custody arrangement that is now. It's would still remain basically 50-50. But I will set up an evidentiary hearing for determination whether or not custody should be modified in any way. That's what you have to bring to me today. I find that there is that one incident, if it is one incident, does provide enough for me to have a custody hearing on this matter. So we'll send out notice as to when it is. Both of you should get attorneys if you know what you're doing, because you won't know what you're doing in a custody hearing. All right. It's a formal hearing that you have to bring in witnesses. Testimony is taken, all kinds of stuff has to be taken care of. I will say that if there is any other hint of substance abuse, ma'am. In the meantime, sir, you should seek an immediate ex parte order, is what I say, to have the kids remain with you. But it doesn't change anything right now as far as what the kids do. So that's the ruling of the court. We will set up an evidentiary hearing. You will get notice of it at your residence. There are certain things required in that hearing. The notice will say you've got to exchange witnesses, exhibits, things like this in a timely manner. I expect everybody to follow it. You take it to an attorney, they clearly know how to do it. Otherwise, you're going to be responsible to do it yourself. Okay. Sir, you understand?
I understand.
All right, ma'am. Thank you all. Take care. We're adjourned.
Thank you.
Both parties are present on Zoom. This is a pretty simple motion that request from the mother plaintiff to simply change the exchange location. It's my understanding. Is it right now the party getting the child is supposed to pick up from the other person in order? And that's not a good idea since there's clearly a PPO, or at least as I understand it, there's a PPO against Mr. Albright from being around you. Is that right, Miss Bricky?
Yes, sir.
All right, so let's figure out a better place and thing to do with this. Mr. Albright, she has suggested a couple of locations. It's best for you also because I don't want you at her house. That would.
I'm not going to her house. Somebody else does the pickups for me.
Yeah, well.
And then she picks up from my house.
Well, that's not a good idea either because she's got a PPO, and if she comes and picks up from your house, it looks like she's violating her own order. So we're gonna pick a neutral spot somewhere. You've also moved away from where it was. What's a good spot to pick up? What about 44th and 131 or something like that?
I wouldn't be able to make it that far. I have restrictions on time on when I have to be home.
What do you mean?
I have a tether.
But you're sending somebody right now as it is, right?
She's not able to do it then because she has a night job. And I don't have anybody else to go.
I don't understand what you're saying. How does she pick up now?
Right now they pick up at like when they get out of school.
Okay.
That's 3 p.m. That place is that's fine.
That's fine, ma'am. You don't have a problem with that.
Yeah, so basically what the problem is for me for my pickups for when
Yeah, so he can still pick them up from school. That's not a problem.
Yes.
So that he's
Yes.
got that person. And
Yep.
then what about some kind of a location, sir, for drop off?
I could do nearer to my house. There's on 131 and M222. There's a gas station there.
My biggest concern is the fact that I have to drive almost 45 minutes consistently due to his move to Allegan, whereas he was closer to where
How far did you have to drive before?
12 minutes. And he also works close to where I live. So
I don't work close to where she lives. Last night I was working in Saginaw. I work all over the state.
Look at you. Is there a reason we can't do? I mean, you're down in Allegan. I'm assuming that you can take 131 is somewhere near there. Is that right, sir?
Right, that's what I was suggesting. 131 and 222. It's the Allegan exit. There's a gas station right there, a J&H.
We don't. I understand. I'm kind of, but
Sir, can I mention another concern I have, please? My other concern is for the kids because after a long day at school, he picks them up at 4:30 and drives them 45 minutes to Allegan. And then 2 hours later, I'm picking them up from Allegan and driving them a whole 45 minutes back. That's like an hour and a half for the kids in the car after a long day at school. That's where my big concern is for them.
I requested overnight since the beginning of the divorce and offered other solutions to that where they wouldn't have to drive.
If you're asking, what are you asking then? You're trying to change parenting time then, ma'am, and that's not what you're asking.
I'm not trying to change parenting time, sir. I'm just trying to change the pickup location at 7 p.m. to be.
The kids are going to do the same amount of driving no matter what. no matter who picks them up, where, when, whatever, they've still got X number from pickup at school to going to Elegant to meeting somewhere in between. And I'm not against having some kind of a midpoint, not necessarily at 131 and the expressway. It can be a little bit up this way. You've already were driving 12 minutes, so you know, if you have to drive 20 minutes, you say that he's 45 minutes away.
I'm not 45 minutes away. I'm 38 minutes away. And prior to the divorce, you know, I was 12 minutes for a minute, but before that, I was living in Cedar Springs with my mother. This isn't a new distance.
I am going to set a time, all right? If it's she can drive, you can add 8 minutes to your thing and drive. I don't know where on 131 at an appropriate gas station.
On the motion, if you look at
Yeah, it says 84.
number 14,
Says
there
84.
is a location, Byron Center Family Fair, and that is about the same distance that it was to pick up the kids at the time of the divorce decree, which is that about
Well,
15 minutes.
let me just make this kind of clear to you. People are going to move some during this time and that kind of stuff.
Yep.
And we're going to have to work with it. It doesn't mean that, I mean, if you move it all, you know, you're going to have to pick up time. He's going to have to pick up some time, and I understand that, all right? But it's only a little bit different for you if you have to meet, I don't know, at the Whalen exit or something like that. I don't know what is specifically right there. But that's something that you're going to have to do. Where is it, sir? Not just at the Allegan exit, coming north. What is about a halfway point?
Shelbyville.
Is that?
I'm not sure what that is.
It's 124th Avenue. It's
What about
right by the casinos.
What about the Whalen exit?
That's a significant further. That would.
It's not going to kill you.
I mean, I don't understand why currently
exit.
the pickup, I already have to have somebody from Allegan drive to Grand Rapids to pick up my kids for me.
And why is that? That's your doing. All right? That's your doing, not hers.
There is a Culver's at the Wayland exit that you mentioned that would work fine. At 135th Avenue.
I can't meet her anywhere. I don't have anyone to meet in my stead. You said she can't come to my house because it looks like she's violating the PPO, but
It's not appropriate to make her go to your house when she's got a PPO against you. That's your doing.
Right, and I'm offering a 20-minute drive from the 222 exit isn't right next to my house. It's 15 minutes from my house.
I didn't say it is.
Wayland's 30 minutes. I'm taking most of the trip.
You
on
moved.
top of having someone.
You moved.
I had to move. I was forced out of my home.
You moved. Now you got a PPO against you.
I've had it since the entirety of the divorce.
Yeah.
That's not anything new.
Well, just telling you. We can meet at the Culver's at the Whalen exit.
At what time? Because that's losing time with my kids.
7 p.m. the pickup time.
Same time. They're not changing anything else.
And if I don't meet her there, because I don't feel comfortable, I don't feel safe meeting her anywhere. I only feel safe at my home because there's 2 cameras watching and I can clearly show that I'm not anywhere near her. I don't feel safe meeting her anywhere. The last time I was anywhere near her, I was arrested.
Around you. She doesn't feel safe being around you. That's why you're in a public location where there's, I'm sure there's cameras at Culver's.
Yes.
And that kind of stuff.
I've been to Wayland. I wouldn't put a lot of cameras outside of anything in Wayland.
Yeah, they do. My clerk lives near there. So,
I still don't feel comfortable meeting her.
Well, then don't pick the kids up then.
So you're saying because she can't drive
I'm
an extra
telling
20
you,
minutes, I can't have my
telling you
kids?
that the order of the court is you'll meet at Whalen for the exchange at 7 o'clock. You can find somebody else to take the kids there.
I can.
Whatever you need to, work on it, but you moved and you got the PPO against you. It's mainly your problem.
The
End of
PPO
story.
doesn't get to continue to punish me for everything. I've been punished with the PPO. It does, and now every decision by the court is, oh, well, you have a PPO, so we're gonna in favor
Yeah,
of her.
because we gotta keep her safe, because obviously you've
I have done
things that are
nothing
not
to harm her at
appropriate.
all.
So the meeting will take place as I've stated. Thank you. We are adjourned.
Thank you, sir. Have a good day.
Pethers versus Carr, both parties are present via Zoom. This is a motion that has been filed by the defendant mother regarding custody. There was a custody order for joint legal with mother having physical back from 6/16/23. It appears that that the plaintiff has every other weekend from Friday to Monday morning and every other Wednesday from Wednesday after school, like till Thursday morning. I do note there's a bench warrant out for Mr. Pethers. Primarily, I think it's for child support because he's like $8,700 in arrears. And I think it's still an active warrant. On 9/10, let's see, I made an order where the father was to have parenting time. I changed the parenting time at Woodland Mall from noon until 1:30 each Saturday, I believe it was. On 9/26, there's an ex parte order that denied, looks like it suspended dad's parenting time altogether. Mother is filing, I guess she wants to continue the suspension or something of the parenting time. She's got some things in here that, sir, you sent to her, emails and whatnot. Don't sound, they're not very complimentary of you and what you say. So what are you asking for, ma'am? You're asking for continued suspension or what?
Yes, sir, and sole custody.
Well, you have full physical custody. If you're asking for full legal custody, there's been enough problems between you that I'd probably have to have an evidentiary hearing on that.
Okay.
And you're
Why
asking,
would you try to take the kids from the father, period?
sir, I'm gonna ask you, what's your response to everything that she's got here?
Well, this has gone from, it's not very complimentary at all. We went from having these kids to 50-50, 50-50 dropped to what you gave us. Now it's to this. There's no reason to keep me from them kids. Never been endangered with them kids. I mean, there's a lot of
You got an
things.
alcohol problem.
I've been dealing with my alcohol problem.
I'm not sure it's been successful. I mean, it's pretty
That's on
clear from a
paper.
lot of the stuff in here. Are you,
There's no reason these kids should be taken from me, period.
nobody wants to take your kids from you. They want a good, safe parent.
That I am. I mean, these kids are going to lose their childhood without me.
And also you're not very appropriate in the way you communicate, which I read on the record, but they include calling her a lot of stuff. And I don't know how you expect to raise kids jointly when that's the way you communicate with the mother.
We don't communicate barely at any point, period.
Well, no kidding. With what you call her, I wouldn't communicate with you either.
That goes back and forth. That's
Well,
just
I didn't
not
see a
one.
lot of that, but I mean, you've done things like, what was the place you were at that you had to call somebody because you were so drunk with the kids that,
That's what she puts down. I mean, if we're going to talk like that, we should be talking about why the CPS things that I have had to bring to the court's attention. I mean, these things are real.
substantiated?
What's that?
Just because you make a complaint doesn't mean they're substantiated. Are you saying they were substantiated?
I have no idea. I mean, like real deal things that happen with these children in her possession are something that should be looked into. I mean, she wants to scribble on a piece of paper and say I'm this bad guy. Ask the kids. I told you that last time. These kids don't see me drink. these kids have fun with me every time. I mean, these kids mean everything to me.
So why didn't you exercise your time at Woodland Mall?
The Woodland Mall last week is because I had to work. I mean, you guys are asking $1,000 a month from me. The time before that, I was in a rehab center trying to better myself.
So you were in a rehab center. How long were you supposed to be there?
I was there, completed the program, 30 days, 30 some odd days.
Ma'am, any response?
He told the children that he was having back issues last week, and also there are more text messages, excuse me, to myself, to my father, and to my brother from Mr. Puthers all last week, harassing all of us.
Your
I
father almost killed our daughter with GHB. This is a real issue.
Sir, I'm gonna tell you right now, I give you your chance, sit down. I give you your chance to talk and her chance to talk. You're not gonna interrupt. She didn't interrupt you. Go ahead, ma'am.
He has sent multiple text messages calling us different names, making unsubstantiated claims of my dad trying to kill our daughter, which I think is really crazy because back in January, Ryan asked my dad to come pick him up because he was so drunk at a homeless shelter that he got kicked out of the homeless shelter. So if he had such a big problem with my dad and he thinks that he's such a crazy person and tries to kill our daughter, why would he be reaching out to him to go buy him bottles of liquor and pick him up when he's stranded?
Well, we're going nowhere with that stuff because I don't know if it's true or not. Okay, obviously you're saying it is, and he's probably gonna say it's not. Anyways, what I'm gonna end up having is an evidentiary hearing regarding parenting time and whether or not the parties, it looks like just from the language and from the things that are going back and forth, that these parties cannot cooperate in a joint legal manner, that the parties have to talk to each other about the major decisions. I don't know who should have legal custody or if it should change, but there is clearly enough to warrant a evidentiary hearing regarding legal custody. As far as parenting time, it's been, I mean, Judge Hillary issued an order that suspends your parenting time, I believe.
The ex parte motion was denied. But I submitted the ex parte motion because I am afraid to meet up to even deliver the children because of the threats he makes.
But I've got him meeting him at the Woodland Mall. I mean, if he's screaming and hollering at you there, just tell a security guard and you know.
Your Honor, for the last year, I've been picking those kids up at her residence, picking them up, dropping them off. We never see each other. There's no threat that she's going to be anything. I'd much rather not say a word to her, to be honest with you.
Your texts don't show that.
Well, when somebody tries to take your kids away from you and the action that she's doing it in is pretty ruthless.
Well, but look, she's asking for it and I'm giving some of it to her, partly because of things like, being so intoxicated that you got to call for help when you've got the kids and things like that. It's just, is there something in the judgment that says you're not allowed to drink while you're around the kids?
Yes, there is.
Yeah. But it's clear that there have been times that you have. You've clearly violated that. You know, it says father prohibited from consuming alcohol for 12 hours prior to and during any parenting time. There's clearly times you've been drinking. I'm not saying the kids are watching you drink, but there's clearly times you have. You've had to call for help while you've had the kids. I mean, why are you violating that part of the order?
Your Honor, what I'm doing is trying to get away from the status of addiction. And I've gone through over a year now of doing so.
I'm not saying you're not working at it, but you're
It's no
not
reason to take
allowed to
my kids
have the
from.
kids while you're drinking and stuff like that. And
Well-
clearly you have had them and been
And I
drinking.
can rebuttal and I can be like, why is she keeping the kids from me every holiday? Why does she get this?
Did you file a complaint with a friend of the court?
No, I haven't.
That's the way you enforce that. If she's keeping the kids from you at times that you're allowed to have them, and you think that's inappropriate, you file a complaint with a friend of the court, they investigate it. And if you guys can't.
Where's all this money supposed to come from?
What?
All this money, it's what, $100 and some to file another complaint after complaint after complaint. You
I
file
don't
with
know that it costs you
CPS,
money to file a complaint with a friend of the court. You're
it costs
telling me
over $100 to do it,
to file a complaint?
to file the motion.
A complaint with the friend of the court.
I'll keep that in mind, Your Honor.
Oh, well,
But
thanks.
I mean, I've done CPS and they haven't done anything, and that should be definitely looked into while my kid
Maybe
is
it's
performing
because
sexual acts
maybe
on.
it's because
his cousin.
CPS looked into it and didn't find anything there.
Well, then you got to be able to see that the coaching is going on over there. Then, I mean, this just doesn't come out of nowhere. It's not pulled out of a blue sky.
All right. Anything else? We're gonna have an evidentiary hearing regarding parenting time and legal custody. We'll set it up as soon as we can, see what happens. You both will need to follow the order that is going to go out. We'll tell you when you have to exchange exhibits, when you have to exchange witnesses. A trial brief that will have to be submitted to the court in a timely manner before we have it. All the hearing will be a formal hearing, meaning the rules of evidence apply. You better, if you have any common sense, you'll hire an attorney because you have no idea how to do this. But I'm gonna hold you to the formal hearing like I have to when you have the evidentiary hearing. We're not just gonna sit and talk about it. Do you understand that?
Yep.
Ma'am, you understand?
Yes, sir.
Until then, the parenting, I'm not changing anything, and the parenting time takes place for an hour and a half on Saturdays, unless you want something different. If you'd rather have supervised journeys or something, so both of you are protected, that's fine, but we still have the same thing, noon until 1:30.
I can't get my kids overnight. They can't come
Right
home.
this minute, I'll fix it if I have to fix it.
It's just
That's
not
why I'm
right.
having a
This is
hearing,
just
so I
not
can,
right.
so I can figure it out, because you say it's not right and she says, yes, it is, because he's got these problems, and you basically say, yeah, I'm fighting addiction and all that kind of stuff. And I don't know, because I haven't taken any evidence right now, and I'm gonna take formal evidence when I have this hearing, and I'm gonna figure out the best I can. Unless, do you wanna go to the friend of the court and have them look at parenting time?
I think that'd be best. I mean, I don't got another $15,000 to spend on a lawyer.
I can't help
I
it.
mean, these are my kids we're playing with. This isn't a sweatshirt that we let somebody borrow.
All right, ma'am, do you want to go to the friend of the court and have them look at parenting time?
Sure, we can do that.
All right, we'll refer it to the friend of the court. You don't have to do an order on that. Everything stays in place, but they're gonna contact you and they're gonna make up what they think is appropriate as far as parenting time. I'll have them look at, legal custody also. And legal custody and parenting time, and make a determination what they think is appropriate for parenting time. And they'll make an order probably, and if you disagree with it, you have to file within a certain number of days, or it'll become the order of the court. You're gonna get it. They're gonna contact you. You better cooperate with them, or they're only gonna get the other side's part of it. All right?
Thank you.
You understand that?
Yep.
Okay, I'm gonna waive your fees, which is 150 from each of you that I should require, but I'm gonna waive your fees, so you got no excuse not to go there. Good luck. We'll see you later.
Thank you, Judge.
Thank you. The plaintiff is present, the defendant is not. You did give her notice of this hearing, didn't you?
Yes, I did.
You mailed it, you hand delivered it, you said?
Yes, I did.
Okay, looks like about 14 days ago. So she does know about this hearing, correct?
Correct. I asked if she was coming, but she didn't answer.
All right, well, this is kind of a unique case. You've been divorced as a DO for some period of time. Apparently, you had a child during the relationship. The referee found that it was still appropriate to have a DO and allowed you to get divorced. Somebody must have, what was it, Department of Health and Human Services or something, said, wait a minute, you gotta have a father declared or whatever?
Yes, that's correct. That it was them and the people that give out the birth certificates down at City Hall.
All right.
They told me I had to come here first because there was no record since the divorce
All
was
right.
carried to us.
Ma'am, would you please raise your right hand? You solemnly swear or affirm testimony given in this case to be the truth, whole truth, and nothing but the truth.
Yes.
All right. I understand that there was a child that was conceived during the marriage, but is not the plaintiff's or the defendant's child. Is that correct?
Correct.
Now, I note that you're both women, and so it's an impossibility to have that. My question to you is something like the defendant's egg was not implanted in you or something for that child. Is that correct?
No, it was not.
Okay, so there is no possible way that she is the biological parent.
Correct.
Has she had any contact with the child since the child was born?
No, me and her were separated a little over a year before I ended up pregnant.
All right, and so, I mean, she hasn't been contacting you, say, hey, wait a minute, that's my child, I want, because
Oh,
we're
no.
married or anything like that?
No, nothing like that.
Okay, she knows you have a child, I take it?
Yes, she knows because I have an older child that she became familiar with and she's 4. So she like sees the child along passing of the child of my older child, but it's nothing like, oh, that's my son type of deal.
Okay. And you've also alleged in here that you know who the father is.
Yes, he was my previous boyfriend.
All right, in fact, the child is named Junior after the father, correct?
Yes, that's correct.
Are you taking appropriate steps to make him the legal father?
Yes, I think we have to do a DNA test or something after this. I'm not really sure what they
You can do a
want.
DNA test, or if you both agree that he is, you can sign and file an affidavit of parentage.
Okay, so we'll probably do that since that's easier.
All right, and that should be done as promptly as possible. Having asked Ms. Burrell questions to determine that there is no relationship between the child, I think the child's name is Alonzo, maybe?
Yes, Alonzo Carr Jr.
Yeah, that there is no relationship, that the defendant has not had any relationship with the child. Clearly, she cannot be a biological parent, but could have had a legal claim. She is not even here today to assert that. That I will enter an order that the child was born out of wedlock. And I think that's all you're really asking for regarding Alonzo Carr Jr., that he is born out of wedlock. And then I'm going to take your word for it that you will make sure that the legal father, Alonzo Carr Senior, will take all appropriate steps to make him the legal father.
Yes, I will definitely.
All right, we'll get that order out to you quite soon so that you'll have it, okay?
Okay, thank you so much. I appreciate it.
Thank you, take care. Defendant mother's motion for custody. Best I can determine, it looks like the father has it like every other weekend and several weeks in the summer.
Correct.
This is the request from the defendant to change custody. I think she's trying to eliminate a number of the overnights that he has. Her claims are just, I mean, I got pages of just written here of things that says stuff like, dad yells at the kids, he's bipolar, lives in an unsafe environment. I think at his grandmother's, he has a crazy brother. who apparently might be in jail, I don't know, and he's got a PPO against him or something like that. Thinks he's taking meds that are not prescribed to him. Kids are scared of him. I don't understand what you're telling me about some PPO that is there but isn't being enforced because of a federal child support case. I couldn't follow that. Is that basically what you're asking for?
Correct. Limiting the summers to about a week. The 4 to 5 weeks is pretty excessive. And the unsafe environment goes for the brother who previously lived at the Nana's house. He is currently in jail. He is to be released in January. He had made threats to kill my children. The PPO states that the PPO is on the grandmother, the house that Ben lives at, and my children.
Okay. So, I mean, we can't, it's not against the father, and it's that he's not the one, and there is a PPO out there.
Correct. There is a PPO out there. However, to me, it's an unsafe environment. As soon as he gets out, I don't see this being an end. His own mother doesn't even see it being an end. She's the one that has a case against him as well.
Well, I mean, I understand, but when the kids are with the dad, just bottom line, the kids are to be protected by the father. End of story. And whatever he has to do, if he has to move, if he has to get a PPO against the brother or whatever he has to do that, I don't know, but we'll deal with that somewhere down the road. I don't know what you were talking about, a PPO that was not served, but somehow because of a federal child support case against the father? What are you talking about?
Correct. There's a federal child support case against the father. I was notified by the police when they were called that weekend that he ended up leaving. I was notified by the police that I have a PPO against him. It's still standing. I don't have any paperwork on it.
Well, you would have been the one to file it.
I don't have any paperwork on the PPO. I did not file the PPO. It was granted by the federal state on my behalf.
The federal state?
So the federal child support, they granted a PPO on my behalf.
You sure it's not the Attorney General's office that has a child support?
Right, Attorney General, which is more federal. It's
No,
not.
that's more state. It's the state of Michigan. It's not the federal government.
Okay, my apologies.
Well, that's why I can't.
But it's not
figure
friend
what
of the
you're
court.
saying. All right, sir, what's your response to any of this?
I have a copy of the police report where Miss Atkins walked into my home unannounced.
I understand. She says she was in there at your request, and you said that you told the police she wasn't.
Yes, I never invited her into my home. I also have a drug test. I report to Karen Fox down on the second floor. I have a letter from her.
What are you on probation for?
For the child support. They have me the pre-trial. I meet with Karen once a month, and I actually just took a drug test on Tuesday. Honestly, this all started after she showed up at my home. Before this, I was with my children. I just moved into my grandmother's house 3 months ago. Yes, I do have a brother in a lot of trouble right now, but there is a PPO. My grandmother has a PPO against him. So when my children are with me at my home, they are covered under that PPO. My brother is not allowed to step foot on that property.
When does that run out?
In a year. I went in, when the incident happened with my brother, the whole family came down here and filed for protection orders. I was denied. My kids, I filed individually on behalf of both of my children. They were both denied. I was denied, but my mother, who I was living with at the time, was granted one, and my grandmother was granted one. And my grandmother asked me to move in with her because she didn't feel comfortable being alone. So I just moved in there in June. So honestly,
So you're there to kind of protect your grandmother,
Yes.
but the problem is that you're there to protect your grandmother and you got your kids there. You understand that's kind of a,
I live there because I don't really have I'm struggling to fix a lot of things. I've made a lot of mistakes in my life. I'm trying to fix them. So it's more or less, I'm helping my grandmother with, she's behind in bills. I pay her to help make sure she doesn't lose her home. And she just feels more comfortable with me there. She doesn't like being by herself. My grandfather passed a few years prior. My grandma's always been in my life. I love her to death.
well, I can understand Ms. Atkins being concerned just because the brother, I mean, not concerned now, because obviously it's gonna be months till he gets out of jail is what.
He hasn't even been tried on what happened yet. He's just in jail on his probation violations, and that's when he gets out from probation violence. He's still dealing with the case.
Do you know what he's charged with?
Domestic violence, second account, and I knew that there was a third account at one point. I'm not sure what is going on with that, but it does not seem like he's going to be getting out in January.
All right, you also understand, I don't want kids put in the middle of this kind of stuff.
Yes, and they aren't in the middle of anything. There's nothing going. My brother isn't around.
And you have are you randomly tested for
Yes,
the
completely
pre-trial?
randomly. I was reporting in person, and then as of a month ago, I put to report by form via text.
Where is your case at?
My case is here.
Yeah, well, I mean, the Attorney General, I'm assuming, is prosecuting you for child support.
Yes.
Where are you at with that case?
I've been working very hard on it. I raised my child support to where I could pay more towards the arrearages to try and make up on it. I just received a letter. I know when the case started back in February, I was at a good chunk of money, about 15,000, and I've got it down to around 10, 11. now.
Is your case still being prosecuted?
It's just, I'm in limbo. I go to court on the 12th. Every time I've been going, it's just kind of, all right, we'll see you in a month. We'll see you in a couple months. And,
Your attorney?
My attorney is Jason. Shoot, I can't think of his name right offhand. I have his business.
Gansman? No.
Well, something else. I'm sorry.
It's all right. You don't need to know. You don't, that's fine. Jason Seifert?
Yeah.
All right. Ma'am, anything else you want to say?
Nope, it sounds like you guys covered it. My kids were there for a majority of the incidents that had occurred with the brother because
That's what it sounds like, and
they're horrified.
I'm sure, and I'm assuming that Mr. Harriman wasn't too happy that it was happening there either. I mean, yeah, you can pick your friends, but you can't pick your relatives, all right? And this guy seems to be out of control, and if those kids are around him at all or anything, you're responsible. Do you understand that?
Yes, I do. And that's why they stopped going to my grandmother's house. Well, he was there. Actually, Miss Adkins and my grandmother always had an agreement, even while I wasn't living there, that my kids got dropped off there. That was her decision. Once everything started happening with my brother, I made it a point that I picked them up and went back to my parents' house with them. They did not go in that residence once anything started happening. I kept my children away from it as best I could, but to be held responsible for a situation that Miss Adkins and my grandmother came to the agreement on, that's not.
All right. At this point, I don't think there is evidence to meet Vadvarka, which is a case that says it has to have proper cause or change of circumstance to have an evidentiary hearing regarding custody. However, there may be in the near future, if things come off the rails at all, enough to look at a change in parenting time some. But right now, he just gets every other weekend, right? Right now.
Correct. And then the huge chunk in the summer.
Well, we got a long time before summer comes.
Yep.
And I guess what I'm gonna say is I'm gonna deny your motion right now, and if because the brother will be like in January, I don't know if he's getting out or whatever, things will be a lot more clear, I think, to everybody come spring. All right. You can renew your motion if you still think that it's a problem come springtime or whatever to kind of, but I'm not gonna cut back his parenting time for the summer when we are months away from doing it. He seems to understand his responsibility. I just think if he doesn't show responsibility towards those kids, I will cut some back in the summer. But right now, I'm gonna deny your motion because I don't think it's necessary. You'll continue with the every other weekend. You understand what I'm saying?
Yes, I
All right, I mean, if these kids become in any way.
I will be filing for another protection order against my brother on behalf of me and both of my children individually, the moment I hear he's getting out of jail.
Well, and
I
it's
will
not
take
just that.
any precautions I need to make sure that with me in my home, my children are safe. As of right now, the house is covered under the no protection order. He is not allowed to step foot on that property.
And what I'm trying to tell you also is I want your kids to feel safe. I don't want you yelling at the kids. I want you to comfort these kids. These kids are 11 and 7, all right? I want them to feel safe when they're with you. I want them to, kids are kids, all right?
Yes.
They sometimes screw up, but I want them to be treated appropriately.
They
If
always-
not, I'm giving you fair warning.
Yes, sir.
All right.
They are, I'm sorry,
right.
but I do not scream.
I'm just telling you, I know you're gonna say no and she's gonna say yes and all this kind of stuff. And if need be, I'll have a hearing to determine what's appropriate. But right now, ma'am, I'm gonna deny your motion because it's for a change of custody. I don't think you meet Varka at this point. But you also hear what I'm saying is that if things are going bad or inappropriate, you can come back in March or April if things aren't looking good and renew your motion, all right? I'm trying to make it so that I don't want these kids to suffer anything, okay? I want them to be able to have a good relationship with their dad and their mom, all right? And that's important. It's important to the kids, and it's important to the kids that the two of you try to work together. I don't know whether or not he invited you over there or not. It doesn't really matter. You're not being charged with anything. Nobody is. You guys got to start acting like adults who are taking care of kids. You got to put those first and foremost and put your own feelings away about this. You gotta get rid of that and let the kids be kids. And when you need to speak appropriately to each other, you need to text appropriately to each other. If somebody's calling somebody's name and stuff like that, names, I'm gonna see it and I'm not gonna be very nice to the person who's doing it. I'm just telling you, you treat her with the respect that she deserves as the mother of your children, and you treat him appropriately too. All right, ma'am?
Yep.
Good luck. Thank you very much. We're
Thank you.
adjourned. Parties are present as well as Prosecutor Ms. Brower. This is date and time set for entering a judgment of support. Mother is deemed to have potential income. She works 25 hours a week for $16.44 at Myers. She's been imputed for 35 hours to a more full-time. Dad's potential income says he works 6 months out of the year. And the others, he just kind of picks up times. He makes $12 an hour times 35. He's imputed as working $12 an hour for 35 for the whole year because he can't work half a year and claim that that's enough. As a result, the child support, and I have gone through the factors for potential income, the amount that is being requested is, I'll get my hands on it right here now, maybe. Is $373 a month for one child. Anything you wish to add, Ms. Brower?
Yes, Your Honor, there was a pre-hearing conference on October 1st, 2024. At that pre-hearing conference, the defendant informed me that he earns $21 an hour and actually works 45 to 50 hours per week. I asked him to provide me with proof of income, and he was like mystified that I would ask him for his proof of income because he stated that he already provided it to another office. I presume FOC. I told him that I wouldn't have access to whatever he provided to front of the court, that he would need to provide as proof of income to me. An argument basically took place, a disagreement to the point that I told them that I would just have to set the matter for a court hearing. But the court has correctly enunciated how child support guidelines were ran in this matter. In addition to that, I gave the defendant an adjustment for 2 other children, and guidelines were ran with the defendant having 0 overnights with the minor child. As is my understanding, that is what's going on right now. I am asking that the court enter the proposed judgment as well as the UCSO. I also wanted to clear one thing up. It's my understanding that plaintiff does not work at Meyer. She's actually working at Corewell Health, is my understanding.
All right, but are you telling me that the defendant earns a lot more than you calculated him for?
Well, he works at Gilmore, and he stated that the defendant told me on October 1st, 2024.
Yeah, I don't work at Gilmore no more.
Sir, stop it. Let her talk and I'll give you a chance. Do not interrupt her again.
Okay. I'm sorry.
Thank you, Your Honor. The defendant told me on October 1st, 2024, that he works at Gilmore and earns $21 an hour times 45 to 50 hours per week. When I ran the guidelines, I used that $21 an hour, but I only used 40 hours per week times 26 weeks, since he told me he works there 6 months out of the year. And in addition to that, I imputed him to $12 an hour times 35 hours per week for the other 26 weeks of the year. And that's how I came up with the income that I used for him.
All right, because all I see in here is his income for 6 months that his job is seasonal, 6 months out of the year. The only numbers that I see in here is $12 an hour times 35 hours. I'm questioning if you gave him the significant amount more that he earned in your calculation. But now, sir, if you wish to say something, you may say something.
Yeah, I don't work at Gilmore Catering no more because I had to switch my jobs because of the time conflict.
Time conflict?
Yeah.
What?
You said what?
What is a time conflict?
Because like how my job is like I can't afford to work at that job and pay child support, so I had to get another job so I could work first shift because there's no first and second shift.
So how much your other job pay you?
My other job is $18 an hour now.
Is $18 an hour?
Yeah.
Times 40 hours a week?
Well, I don't know yet. I just started.
Where do you work?
It's Yo Chef Catering.
And you're going to provide, you just started?
Yeah.
I thought you were earning $21 an hour at Gilmore.
I know, but how much the child support is, I can't work there and survive. So I got to get a first shift and a second shift job. Cause there ain't no shifts. You come there, you do the party, you work and you do your stuff and you leave. Ain't no second shift, first shift and stuff like that. Cause you might come in at 8 o'clock and you might leave one day at 5, but then the next day you got a party, you got to come in at 1, you don't leave till 8. So it's like 2, spontaneously to work another job. So I had to quit that job so I could find another job so I could keep up with it.
Brower, did you look through your calculations and help?
I mean, Your Honor, the way that I ran guidelines, so I imputed him to $2,730 per month. So when I use the $21 an hour times 40 hours per week times 26 weeks per year, that's $21,840 per year. And then $12 an hour times 35 hours times 26 weeks is $10,920 per year. When you add in the $21,840 and you divide it by 12, that's why on the guideline, it states that his gross monthly is $2,730 per month. That's the income I imputed him to. If the court would like me to use something else, I'm amenable to that, but that's how I came up with this calculation.
Basically, you added 6 months at $21 an hour and 6 months at $12 an hour.
Yes, Your Honor.
Together to come up with an overall year amount, divided that by 12.
Yes, sir. That is correct.
All right. Ms. Robinson, anything you wish to say about this?
No.
No? You believe, all right. Well, I understand how the calculations were made. I don't know what Mr. Makura is doing now as far as wages and whatnot changing. If he wishes to provide information as to a change in wage, we'll certainly take a look at it, but under the circumstances here, I think it is appropriate. The calculations are as good as we can get considering what the defendant is making or allegedly makes, so that amount is $373 a month. Any objection to that, sir?
Can I speak?
Yes.
Oh, so what is my total child support that I gotta pay altogether?
$373 a month.
I'm talking about what my other cases.
I don't know. I'm not finding that on that. You're giving credit for other children, I think, in the calculations, weren't you, ma'am?
No, it don't sound like you, because now,
Yes, it
now
does.
I will have to pay
You've been
$1,500.
given credit for additional children. That subtracts $560 from your income. That's according to the child support guideline schedule that we have. Therefore, that's the amount that it comes up to, is $373. I'll enter that order.
Okay, thank you, Your Honor.
All right, good luck, everybody. Thank you. We're adjourned.
Thank you.
Via Zoom. This is the request from the plaintiff to transfer basically money from an HSA account. Wants to find out how much there is and transfer it. But it's not in the judgment of divorce. Sir, do you have any, you didn't answer, so what's your position on this?
Yeah, we mutually agreed to transfer $8,000 from the HSA to her HSA when she could get it open, but she couldn't open it till the divorce was done. So there needs to be something in the divorce decree or a document from the court for LMCU to release it to another HSA with a new Social Security number on it as the primary.
So what are you asking, ma'am? What am I supposed to? You want to draft an order that you want me to send? Because look, here's the problem. It's not in the judgment of divorce, so there's nothing for me to enforce. Nothing. You drafted the order. It's not in there. All right. So I cannot enforce anything that's not written in there, even if you guys have an agreement. If you guys want to send forth a stipulation and order as to modifying the judgment of divorce, I'll sign it because you guys agreed to it or whatever. But it's not in there, and you even drafted the divorce, ma'am. You drafted the judgment of divorce, and if it's not in there, the court can't reopen and stuff like that. However, to effectuate what both of you say is an agreement, then you need to send an order in to me that both of you sign, so that you open up that or something.
That's what I was informed and assumed that this hearing was about. So can you?
I'm not going to draft it because I'm not going to order anything because you don't have it in there. All right. And you can't go modifying it. But if you guys need something from the court, you can send it in as long as both of you sign it and agree to it as a stipulation or something, because you need something that says something to open up the account. I'm not.
How
We're not
how do
going-
we go about doing that then? That's what I thought this was, I thought that's what this was gonna accomplish or we could achieve
No.
doing today.
Because I'm telling you, it's not in the judgment of divorce. There's nothing for me to enforce as far as the transfer of something that isn't even listed in the judgment of divorce.
How do we get that, whatever you just said you would be willing to sign? How do we go about, what's that
You
process?
file a stipulation in order or something like that. And if you can't, I can't give you a lot of legal advice. You can go to an attorney and ask them to draft it, a stipulation in order.
Can we just
Okay.
write something ourselves and both
Or
agree
go to a
on it?
legal assistance center and they can help you, but I can't draft it for you here, okay? I'm a neutral party and what you're asking for, I can't even do unless you guys send something in. I'm not gonna issue an order because it's not in a property settlement and you drafted it before and it's kind of like, sorry, you should have done it that way before.
Yeah,
But-
we didn't have an attorney,
but-
so we were
Yeah,
unaware. We
well,
assumed-
that's the cost of doing it on your own, okay?
And I did go to the legal assistance center and this is the route that they told me to
Well,
take.
I'm telling you that I'm not gonna draft the order. You guys can do it. You can probably call an attorney and have him help you out for a couple $100. I don't know, but that's what you've gotta do. I'm telling you now, okay? I'm not gonna
So
do that order.
could you repeat that then? What it needs to be and then how it needs to be resubmitted, just refiled?
You guys can submit a stipulation and order if you want, signed by
Okay.
everybody to the court. And if you put it for Judge Hillary and my attention, with a signature line for me, I'll recommend its entry just because if everybody agrees to it, there's no reason not to. All right? There's no reason, I'm not trying to not help you out. I'm telling you what I will and will not do, okay? If I get that and the two of you agree to amend your judgment of divorce to allow for whatever it is that has to be done. I don't even really know that you have to have something open that you can't open otherwise.
Yeah, it's kind of in a black hole area, just I guess, in the future that you can't transfer anything until you open a new HSA, but you can't open a new HSA until a divorce is final. So
Well,
it's
you
like
do have a final divorce, so why don't you take that into
they
the Michigan Credit Union and say, hey, look at this is final and I'm getting my own HSA.
because they won't allow it because it's a different social security number as the primary. The bank stopped it, so they won't allow me to transfer money because of the tax implications on a health savings account.
Well, you're gonna have to figure that out. And if you send something to me for signature, I'm not gonna stand in the way of it, all right? Because I understand what you're trying to do. I'm not gonna stand in the way of it. I'm just not going to, I can't modify a property settlement. And you're asking me to modify a property settlement with adding something to it. And I
I
don't
guess
even know what I would draft. If
Yeah,
and
the legal
quite frankly, I can say, yes, okay, submit an order and I'll sign it. That's all I'm required to do. All right,
the legal assistance center, when I went down there that day to file for this, when I wrote in there what this was going to be about, I thought that was what we were filing, like for you to sign off and say, okay,
okay, I'll sign off and say, okay, but you gotta submit it to me of what I'm signing off to.
the transfer of $8,000 from one HSA fund to another.
Whatever it is. See, I'm making you responsible to draft it because you drafted everything else. The court doesn't draft orders unless you're
Well, I
lucky.
thought that was an order when I wrote down what the hearing was for today. I thought that was.
Okay, even if I order it, I'm telling you to draft it and send it to me, because I don't have to. The courts don't draft orders unless, I mean, sometimes we do just out of it, but I'm not even really sure what I'm supposed to draft and I'm not going to draft it. I will sign the request when I get it. Just like the last case that I had for child support, I will sign the order when the prosecutor provides it to me. I don't draft the order.
Okay, well, I thought that's what that
Okay,
paperwork
well,
was stating.
I'm telling you, that's not what
Okay.
it is. And if you need help, just go hire an attorney for $500 and tell them what you need and have it drafted and get it through here. You can tell them that I said I'll sign it, a stipulation and order. I want both parties' signature on it.
Okay,
All right, good luck.
thank you.
Thank you. We're adjourned. Is there present via Zoom?
Yes.
This is the plaintiff, Miss
And
Hallam's motion. It's an objection to the friend of the court report and recommendation. There was a referral to the friend of the court regarding parenting time. It was sent out. An objection was filed by the plaintiff. I can't enter an order then. I'm not sure, ma'am, what the heck you're objecting to, but I can't. I mean, I guess I can
I
set an
don't agree for
evidentiary
him to
hearing.
have his parenting time back because my daughter's anxiety because he keeps telling her everything going on in court. He keeps telling her
I'm gonna set up an
details.
evidentiary hearing on this matter and you both have to come in. If you don't have attorneys, you'll have no idea what you're doing. You can object to the recommendation. We'll set up an evidentiary hearing regarding parenting time. Make sure that you follow everything that's in that order, like providing appropriate witness lists, as well as any other.
I understand.
That you intend to introduce for this hearing. Order it, and a trial brief will be submitted as it states.
I really don't
order.
want to go to trial for that at the end.
So you're both gonna need attorneys because you won't know what you're doing, but I'm setting it because I can't enter the order from the report and recommendation. Thank you very much. We'll see you at the evidentiary hearing. It will be in court, in my courtroom, and you will follow what I
And what
state
day would that be?
Well, you'll get notice. I
Okay.
don't know. Good luck, everybody. Thank you.
Thank you.
This was a motion filed by the defendant, Ms. McQueen, who's got a Holland's Head is her name, but Ms. McQueen filed this motion regarding parenting time. Mr. McQueen has never logged in for this hearing, although it was scheduled for 8:30 and it's now 11:30. Let's see, Holland's Head, how did you get him notice of this hearing?
I sent him certified mail,
When was that sent?
October 8th.
October 8th. All right, so it clearly went to his last known address.
Yes.
Did you get like a return thing? or
No.
not? You mailed it October 8th. This is the 18th. And that is sufficient time to get it to him since it was mailed to that address. And like I say, he has not shown up. This is the defendant's mother's request to modify parenting time. There's a whole list of things that she is claiming that dad has not done, including the most recent, let's just go to the most recent, saying that earlier this month, she sent her 12-year-old daughter over to the father's place, Tia, and Tia came back the next day, said she was never going back, that the place was, he was using drugs, that the place was flea infested, didn't have working utilities, and whatnot. That seems to be the most recent event. There have been complaints also that mother has filed regarding the parenting time that he exercises, and that he sometimes is only using a generator because he apparently doesn't have utilities and whatnot. And I believe you said you've been called because there's no food there or something and had to provide money to the child. He seems to be completely off the rails. Does that pretty much sum up what you?
Yes.
What are you trying to do? You want some, I can't eliminate his parenting time altogether, but you want supervised parenting time, I guess?
That would be ideal.
Usually supervised parenting time, I can set up at a place like Journeys where you bring the child there and he goes there and there's a supervisor, they go into a room and he gets an hour and that kind of stuff. Is that what you're looking for at this time, or do you have some person who could supervise parenting time?
Not comfortably. No, I don't know who she would be comfortable with hosting that supervised parenting. or that would be trustworthy enough to.
All right, we're gonna set up an hour parenting time every week at Journeys. You'll get an order stating what it is. We'll see if he will be responsible to pay what is not covered by the by a grant that we get there. You'll get an order saying that you will have to make sure that you contact Journeys. It's down here in Grand Rapids. I thought you lived up there. I thought
Yeah.
Greenville or something, but that's the only one I can think of that does a supervision at this point. And
I presented like a potential schedule, that would be different than what we had the last time that we seen you. I don't know if that would be something more realistic. It's just no overnights.
I mean, well, I can't give you supervised and time with him. If you want to eliminate the overnights for right now, from what I see, it would be appropriate, and you can try and see what it is. What do you think would be?
I think that would be a more, with Tia being 12, she unfortunately has had to stand up for herself. She's strong and can. So I'm not so worried about the supervision. I'm more just the overnights when she goes there is when things start to fall apart for her when she's there.
So his parenting time order is from, like, he gets significant parenting time.
Yeah.
Tuesday
So
after
that's,
school until 7 PM, and then every other weekend he gets from Wednesday after school through Sunday.
yeah. And he hasn't exercised that. She's been with me since June. Unless she starts missing him and gets a hold of him. So what I think and what her and I have talked about, she kind of just wants to go for, a day and no overnights there.
How about we do every other weekend, but it's only from Saturday at 10 till Saturday at 6, and then Sunday at 10 till Sunday at 6.
Yes, that sounds very good.
That's every other weekend. We'll see how it goes. At 10 to Sunday or Saturday at 6 PM. Same on Sunday, every other weekend. And let's see how that goes, okay?
Yes.
So it's every other weekend, Saturday at 10 till Saturday at 6, Sunday at 10 till Sunday at 6, every other weekend, and we'll see how that goes. All right?
Okay.
I don't know how does he have her this weekend, or I mean, what's going on?
He hasn't had her since June. She went there 2 weeks ago and said she's never going back.
Okay, well, we'll start as every other weekend next weekend.
Okay.
So you'll get that order in the mail. All right?
Yep.
All right, we'll see what happens from there. Good luck. Thank you.
Yep. Thank you.
Ms. DeHaan is present from the prosecutor's office seeking to enter a judgment of support in this matter. She's calculated with father having 52 overnights, mother's being imputed as underemployed, as doesn't work a lot of hours. Father's income has been found to be actual income from an employer. Ms. DeHaan, anything you wish to say?
Yes, Your Honor. Thank you. Good morning. This case was filed on May 15th and service was proper on May 30th. We did receive a response from Mr. Carroll also on May 30th. Notably, Your Honor, I did speak with the parties multiple times in this case. And as the court is aware, there was a gap in my progress in this matter as I was out due to a very terrible concussion. But upon my return, I was able to continue progress on this case. Your Honor, I do believe that the child support amount is appropriate. The main concern that I have is the effective date. At the time that I drafted the documents, I do believe the proposed effective date of July 1st was appropriate. However, since I scheduled the matter for hearing, I did receive documentation from both parties indicating that Mr. Carroll has provided some amount of support to Ms. Gray. However, those sums are not quite the same as the child support recommendation. Notably, Your Honor, in July, it's believed that he provided Miss Gray somewhere between $50 to $88. In August, he provided around $200. In September, he provided her with $121. And then in October, I believe so far we're at $40. So I am requesting that the court, with that information, determine an appropriate effective date that would be sufficient for this matter. Thank you.
All right, you have an effective date of 7/1, is that?
Yes, Your Honor, that's correct.
All right. Ms. Gray, is there anything you wish to say?
No, I don't think so. Thank you.
Mr. Carroll, anything you wish to say?
The findings that the amount that have been kind of calculated is well beyond what is available at the end of my payroll, at the end of my cost of living, by almost double, if not even more. So I don't have the means to try and make a $600 a month payment. So I'm hoping to, I have no interest in not supporting Renly. I would love to support Renly. I have every desire in the world to help with her and to be part of her life and everything like that. I just can't. I work full time and I still don't make the 600 some odd dollars a month extra to be able to compensate that much. So I'm hoping
Extra,
to get.
it's money. When you work, your first obligation is child support, whatever's
Right,
left
I
you
understand
live on. And the calculations, there's nothing in here that indicate that they're incorrect whatsoever. It's what you would pay. It's what somebody sitting in the courtroom would pay if they made the same amount and she was. We've increased her income, even though she doesn't make it. Given credit for her making more than she does, because it's not fair otherwise, that she can
No,
work
and I understand
hours
that.
a week and not have to work more. That's been calculated in it. The numbers are correct. They come from a computer program that, unless there is a deviation factor, which there is none in this case, I am to follow. I will follow that. The only break I'm going to give you is instead of going back and trying to figure out every money that you gave one way or another, I'll start at August 1st. That's intended to give them credit for the $600 and some for September or for July. And then we won't have to try and get $40 from here and 60 from there and all that kind of stuff that's been paid. Ma'am, you understand what I'm doing? Miss Gray?
Yes, I'm sorry. I do. Thank
That's
you.
right. I'm giving him basically a month credit because he has given you some money, even though it hasn't been $650. But I don't want to have to, otherwise you got to go back and figure out exactly how much and give him credit. I'm going to give him credit for 1 month payment. It'll start August 1st.
That's perfectly fine. Thank you. I understand.
All right. Thank you all very much.
Can I also make a remark to the fact? Can I also make a remark to the fact that you guys have me noted as paying? Well, my support in the previous my previous cases, the support that is noted in this is only specified to $956, and I actually pay per paycheck. I pay over $1,100, and then if you break that down to a 26 week pay period or year, that's actually $1,242. So that is incorrect, unfortunately. And I mean, I understand that that's just a kind of a.
That's how much you get for having another child, Miss Dahan.
Your Honor, I did give him an adjustment for 2 children. Notably, the calculation, just for the record, his monthly gross income is $5,311.42. With the adjustment and many monthly deductions, $2,442.41 was removed. As such, his monthly net income and available income is $2,869.01, and that's what was used for the calculation.
All right. Thank you very much. Your objection's noted, but you're given the credit in here that is appropriate. We'll enter the order when you send it to me, Mr. Thank you.
Thank you, Your Honor. I'll amend the effective date to be August 1st and have those documents sent to you via DocuSign this morning or this afternoon by my clerk. Thank you.
so my understanding right now, I don't have the option to dispute at all. It's
You can appeal.
essentially
You'll get an order and you can appeal it.
Karen, I'll give you a call this afternoon, okay?
okay.
This is Bailey. Richmond Jones versus Liana. Mr. Liana is present. He filed a motion. How did you get the motion to the plaintiff?
So we did mail her a copy as well to her address.
When was that?
I believe this was, so I know that she did receive it. She did reach out to me. I believe we mailed it out a week or so before we sent the documents to you guys.
With notice of today's hearing date?
Yes, sir.
She hasn't been present, never logged in. This is the Mr. Liana's motion regarding custody.
Yes. And she reached out to me, because we've done this in the past, I'm sure you can see. And typically when we do have these hearings or it's time to show up, she'll kind of reach out and we'll discuss a way for us to kind of co-parent amongst each other. And with this specific situation and the things that's been taking place and her not following through, I just want to do my part. So then it definitely shows that, you know, I am showing up and I am here so that we can be able to co-parent together and I can offer support when it comes to honesty.
So what are you asking for?
So I was previously, we discussed honesty schooling with me and definitely split parenting time, because I'm not looking to, you know, like try to take the rights away from Diamond at all, because she is definitely a wonderful person. The objective is really just to ensure that Honesty has the support that she needs. Her school calls constantly. There's multiple instances where Diamond's father has even reached out to me, called me personally, requesting that I, you know, put things in place so then we can work together versus Diamond and her mother doing it alone. And I know it's trust, because if she did send her to Texas, she wants to make sure that she does come back so then she can visit. So I just feel this would be the best route for us to go. So then there's some boundaries that we are held accountable to.
I mean, okay, but I don't know what you're asking for. You're saying that the two of you are talking and you're trying to co-parent.
Yes.
You're trying to figure this out, and if you want to figure it out, figure it out. I mean, I don't know honesty at all. I don't know you and I don't know mom. All right. So I mean, I don't know what you.
So what would you like advise me to do on my end? Just so then because Diamond really, she said that she would consider Honesty coming here for school, but when it's time for her to come, she never follows through. And then when I schedule a hearing, she reaches out to me and says, like, let's talk it over together. And it's like the back and forth thing. And I just would rather not do it like that, just because of the consistent inconsistency when it comes to actually pulling the trigger to move forward with what we discussed. So my question to you, I guess, would be, what would you suggest that I do?
I can't.
Oh, okay.
I can't.
Okay. Gotcha.
Give suggestions to one party when the other isn't even
Okay.
here, all that kind of stuff.
Okay. Totally respect it.
You know, quite frankly, this is a 14-year-old girl, and you're slowly but surely losing control of her, partly because she's a 14-year-old girl, and she's getting older, and the two of you have got to figure some stuff out. I mean, she hasn't lived in Texas for quite a while.
Definitely.
And you know, And I don't know if it's best for her to go to Texas or not. What you've asked for is a change of custody, but you haven't pled anything that meets what's called vidvarka, proper cause or change of circumstance, that I can read in here.
And where would that be submitted? Would that be like submitted in the packet that we did send over to you guys in the mail?
Well, the packet, I don't know what packet you're talking about. I got your statement, okay?
Okay, yes.
I'm just telling you that there's, I mean, you know, you say she's skipping school. I don't know if she's skipping school or not. You should have some kind of record
Okay.
or something.
Okay.
You know, there's nothing here that gives me proper cause or change of circumstance to have an evidentiary hearing. If I get sufficient information, and I can't tell you what it'll be because it'll fact dependent. If I do, then the best thing that happens is I set up an evidentiary hearing. And that's a couple months down the road. And at least, and then I hear whether or not custody should change to you or not, because I don't know when was the last time Honesty was even with you? It's been 2020 since she lived down there.
Yes, since she lived in Texas, it was last time was 2020.
Yeah, and which, I mean, you say in your pleading, you say she lived with her dad from 2018 until recently, and that's not the kind of stuff you tell the court, because it's not recent.
100%
and
accurate.
it does not give a good view of your honesty to myself.
Okay.
And so I don't know.
appreciate you for letting me know that.
Well, I mean, that's just common sense, all right? If you're gonna expect me to do stuff, I better feel that you're honest.
Okay.
And things. So I guess all I'll say right now is that you haven't met the burden for Vidvarka to change custody. But in the end, you guys have got to figure some of this stuff out.
Okay. And Varka, is it VA or VE?
VODVARKA. It explains that you have to meet a standard of proper cause or change of circumstance before you even get a custody hearing. You're trying to do stuff that people go to school for a lot of years to do and figure that kind of stuff out.
Okay.
All right. So, I guess a denied change of custody. Now I'm encouraging the two of you to figure something out that's in the best interest of Honesty before it's too late.
Gotcha. Okay. Yes, and I do appreciate those information, and I did take some notes, and I would definitely
figure it out. All
Okay.
right, because otherwise you're asking me to figure it out. I don't know you, I don't know her, I don't know Honesty, but I'm gonna make decisions on Honesty that I'm required to, but it
Most
seems
definitely.
like you guys are in a better position than I am.
Okay.
Good luck.
I appreciate your time.
Thank you
Have a
very
blessed
much.
one.
We're
Yes, sir.
adjourned. Mr. Sabani is present via Zoom. The plaintiff is not. We also have the Kent County Prosecutor, Ms. Rummel, present. This is seeking a judgment of paternity as well as a uniform child support order. Reading through the file, father does not deny that he is the father of these two children and did not want DNA testing. So I think we can certainly enter the order of paternity at this point. You don't have any objection to that, do you, sir?
No, I don't have an objection.
Pardon me?
I don't have an objection. Those are my kids.
I'm having a tough time hearing you. Got to lean in closer, but we're going to enter the judgment of paternity. The child support order. There's a lot of background noise there. The child support order is based on your actual income and an imputed amount of $12 an hour for 35 hours that I've reviewed and appears to be appropriate. Anything, Ms. Rummel, you wish to say?
So defendant's income is based on his actual self-reported income of $23 an hour, $23.15 per hour, working 40 hours a week. He did provide me with some pay stubs that shows that He is paid hourly. If he doesn't work, he doesn't get paid like most people. And that he was recently diagnosed with type 2 diabetes. When I spoke with him at the pre-hearing on September 24th, he did not claim, nor has he since provided any sort of medical documentation that indicates that he is incapable of working or is any sort of restriction. I explained to him then that I would base calculations based on his actual income. He also provided my office last week with some documentation indicating that plaintiff had agreed to cancel all of her benefits so that this case might be dismissed and they could sort things out privately. I reached out to DHHS as well as the plaintiff. Both have stated that the benefits are not being canceled. Plaintiff has no intention of canceling her benefits. She very much needs them to support her children. So I would request the order be entered as proposed. Thank you.
Sir, any response? You're on mute because you got a lot of background noise. I don't know what's going on there. Can't hear you. You're on mute. You have to lean in. You have to unmute yourself and lean close to the mic.
My worry is when we talked with her, I told her, you know, I've been diagnosed with type 2 diabetes. And sometimes when I have to eat natural food, it's very expensive for me. It's better if sometimes if I work, if I don't work, I'm not paid. If I work, I'm paid. Me and you, we understand each other. We are from the same country. Our families know each other. We understand, we speak the same language. If I'm sick, this is what happens. When I was sick and I was diagnosed, because every month I send us
That's how everybody works is that way, is that if they're sick, they don't get paid. However, your income has been verified through your own pay stubs to be what it is. If you pay for other stuff, that's it. But I can't not order the amount of child support that is calculated by the computer based on your income, her income, even though she doesn't have an income, and the fact that you are on, that she is on Department of Human Services benefits. And much of the payment that you make probably will not even come to her because it'll reimburse the state for her benefits. Sorry, but that's the way it is. You've shown that you're capable of earning that amount of money and that you do earn that amount of money. So I'm going to order the $751 a month for 2 children.
Thank you, Your Honor.
Good luck, everybody. Thank you very much. We're adjourned.